Testing, this is a test.
Good morning, everyone.
Good morning.
Good morning, Judge Rovner.
Good morning.
We're here today for the first sitting of the 133rd year of this court, I understand. Since 1891, and this will be the first panel that will hear cases. I did a little bit of history work, and I found out that the only business that they handled at that first hearing was the decision to wear robes on the bench. So
I remember it well.
Excellent. Well, we have also the honor of Mr. Newhall and Mr. Glazer. You'll be giving the first arguments of the year, so thank you. We're going to begin with the first case, 23-1557, United States versus Todd Scheffler. And Mr. Newhall, we'll hear from you first.
Good morning, Your Honors, and may it please the Court, Jeremiah Newhall for Todd Scheffler. I want to begin today by talking about the sufficiency of the evidence argument in this case, and I want to begin by talking about counts 3 and 5, because count 4, as the government pointed out in its brief, has some additional hurdles for us to clear. It won't matter if I clear those hurdles if you don't agree with me on counts 3 and 5, because it's going to be the same evidence that needs to be sufficient for all of them. So looking first at counts 3 and 5, those counts were plainly insufficient to prove beyond a reasonable doubt that there was at least a reasonable likelihood at the time that Mr. Scheffler made statements and wrote his report. The statements were made to Illinois State Police. The report was a state correctional form that he filled out. There was no reasonable likelihood that those statements would reach any federal officer. And this
forgive me, Mr. Newhall, but do you think that we can assume that a correctional officer who's been employed at a prison for 18 years has seen at least one other federal investigation of inmate or guard behavior?
No, Judge Rovner, I don't think we can assume that because it's not in evidence. And I don't think that the jury could assume that because while this court might make that inference based on the experience, as your experience as learned judges, the jurors don't have that experience to draw upon or that knowledge of the correctional system. That wasn't presented into evidence that an experienced correctional officer would have that knowledge. There was no evidence put in on that. It's also, I want to take a step back, and it's not necessarily about Mr. Scheffler's subjective understanding. It's an objective test about whether there was a reasonable likelihood there would be a federal investigation. So it's not whether he knew there would be a federal investigation under the test as this court has set it forth and as the Supreme Court has set it forth. It's whether there was just evidence from which the jury could conclude that at that point it was objectively reasonably likely to be federal. And the evidence that the prosecution has pointed to in its brief is the same evidence that the defense said would be the government's best evidence. Both sides in their briefs cite the statement of an FBI agent on the stand that, quote, "we work with state and locals a lot," end quote. The testimony about why the state police brought the investigation to the FBI was, "I don't know why. Sometimes we work together." There was testimony that state police investigate state crimes, the FBI investigates federal crimes. Sometimes they overlap, sometimes they don't.
What about this overlapping jurisdiction idea, though? The two sovereigns have jurisdiction in drugs. The two sovereigns have jurisdictions in firearms. Some are obviously purely one or the other. This civil rights area is something that there is a possibility of being prosecuted in both, by both sovereigns, correct?
There is a possibility of being prosecuted for most crimes by both sovereigns. For instance, Hobbs Act robbery, as this court pointed out when analyzing the same test, is also prosecuted in state court as robbery. They don't call it the Hobbs Act because that's a federal act. As the Ninth Circuit pointed out in a very similar decision, also about a correctional guard, also about an assault on an inmate, also about falsifying a statement in his report, the Ninth Circuit found the evidence there presented by the government was insufficient.
You're talking about the Johnson case?
I am. And the government's brief analogizes this case to the exceptions put forth at the end of Johnson, saying, well, if there was evidence that they frequently investigated prisons, or if there was evidence that particular assaults are routinely investigated by the federal government, or evidence that the federal investigators routinely worked with these prison officials. We don't have that here. And the government's trying to draw too much from the phrase, we work with state and locals a lot by an FBI agent, which isn't even specific to the state of Illinois.
We do know there was a federal investigation. We do know that, for example, an FBI agent attempted to talk to Mr. Irvin, and Mr. Irvin was non-responsive, and that was prior to his passing away. So part of our analysis will have to be, Fowler leaves us with this reasonable likelihood standard. That doesn't necessarily mean, as I understand it, that the FBI investigation must have occurred at a certain time. So if we do have this federal involvement, and this is an issue, this element, we've got a pattern and jury instruction on it, our circuit does. If this element is something then that was before the jury, how was the quantum of evidence insufficient for the jury to reach that conclusion?
Sure. So the quantum of evidence was insufficient, first pointing to there was a federal investigation and that they spoke to Mr. Irving before his death. All of that happened after the acts alleged in the indictments of Mr. Scheffler falsifying a report or lying to state police. There was no federal investigation at that time. So although the federal investigation didn't happen years later, that's not the test. It's whether it was reasonably likely at that time. And the only reason there was a federal investigation that's in the trial record is because the state police came to the FBI and asked them to participate. Why did they do that? The testimony was, we don't know.
So, Mr. Newhall, when you're focusing on the timing, the test is not, so the defendant doesn't have to have the knowledge or the intent at the time that it's reasonable likely for the federal law enforcement officer to get involved. Is that correct?
That's correct.
And so if that's the case, then why isn't a later federal investigation relevant to the inquiry of reasonable likelihood? Because it under 401, it does prone to make a fact more likely than not true, right?
I agree that it's relevant. I just disagree that it's sufficient.
Well, so I think the trouble I'm having with your argument is the sentence in Fowler that the government must show that the likelihood of communication to a federal officer was more than remote, outlandish, or simply hypothetical, right? And so on the one hand, you think a phrase like reasonable likelihood would carry some weight. But then you have that statement in Fowler, which basically to me means it has to be more than simply possible. It has to be more than remote, outlandish, or simply hypothetical. Given the fact that there was an investigation here later on and the concurrent jurisdiction that Judge Brennan mentioned, why doesn't that meet the test?
Because in every case where this arises, there is a federal investigation. That's why we end up in federal court. So if the federal investigation were enough, Fowler would be a dead letter. And this court's decisions applying Fowler and vacating convictions under Fowler would never have been written. The Ninth Circuit's decision in Johnson vacating a conviction under very similar circumstances would never have been written if the existence of federal investigation were enough. It's relevant that an investigation happened, but is that sufficient evidence to show there was a reasonable likelihood at the time that there would be a federal investigation, when at the time there was an investigation of state crimes in a state prison by a state guard against a state inmate? That is...
Mr. Newhall, forgive me, but I take it that it is uncontroverted, both at trial and now on appeal, that Mr. Scheffler was not telling the truth when he wrote in his report. Quote, inmate Irvin was turned over to staff for proper placement without further incident. And if one were to step back and look at the big picture, like jurors do, might, must, you have first a horrific beating of a prisoner. Second, overwhelming evidence that Mr. Scheffler at best stood by and at worst participated. And third, a report by Mr. Scheffler that says, we turned him over to the segregation unit without incident. Can we really say, in your view, that no reasonable jury could convict looking at that big picture?
Yes, we can say that, and this court should say that, because what Your Honor didn't mention, Judge Rovner, is that the jury also had to find there was a reasonable likelihood of a federal, not a state, investigation. And at the time he's writing the report, it is a state correctional report. It is, at the time he's talking to the state police, he's talking to state police about state crimes in a state institution, and there was simply no evidence given about why the FBI became involved other than state police brought it to them for reasons not stated. There was no evidence.
You know, I'm sorry, please continue.
No, please, Judge Rovner.
No, you finish your thought.
There was no evidence of the type described in Johnson, which really factually is very much on all fours with this case, because it's another correctional officer, it's another inmate assault, and it's allegations, conviction for falsifying a report. And yet we don't have the kind of evidence that United States v. Johnson, the Ninth Circuit, said would be sufficient, like evidence of frequent cooperation with that institution or evidence of a policy of investigating inmate assaults. None of that made it into this record.
You see, a problem is that the government has a light burden. The government's only burden here was to show that when Scheffler engaged in misleading conduct with the intent to hinder, delay, prevent the communication of information regarding the offense, that there was a reasonable likelihood that the communication would reach a federal officer. Of course, that is Johnson. And I am trying to get past the fact that when something very serious happens to an inmate and a correctional officer writes a report about it, there is an extremely good chance that that report will go to some law enforcement agency for investigation, whether it be state or federal. It is hard for me to get past the fact that he could not have known that there was a reasonable likelihood that the report would indeed go to a federal agency. And I will agree that it would have been better had the government put on more evidence that more specifically demonstrated that he must have been aware that his false reports would get to federal law enforcement officers, to federal law enforcement officers. But
May I respond?
I think you see our problem here.
I see the issue you're raising. I think the key phrase that you said was there would be an investigation, whether it be state or federal. And the problem that the government has is they have to prove it would be a federal investigation. Certainly, Mr. Scheffler knew there would be a state investigation. That's not at issue. But a state investigation is insufficient to prove this point. I also think your honors have to step back and make sure that you're looking at this as a layperson as the jury is, not as someone who has experience and has seen many cases, which I think is what the Ninth Circuit did in Johnson. I'm very low on time. If I may, I do want to talk about the motions for new trial.
Sure.
The government committed three principal errors in its rebuttal argument. First, by attacking defense counsel and drawing attention to a phrase from opening argument that the jury had been instructed to disregard. And I simply disagree with my colleague on the other side that there's ever an appropriate time to draw the jury's attention to something that the judge has instructed them to disregard. And I don't think that it's ever appropriate to then try to attack the defense attorney's opening argument when you're there to argue about whether you've met your burden of proof beyond a reasonable doubt. Second, the government asserted that there was no assault on D-Wing, and that's just clearly contrary to the evidence. And I do want to take a moment and clarify, because I think that the briefs have talked past each other a bit, and the government has made a good point in that the defense has talked about all the assaults in R1 as sort of a group, and the government is saying, well, we want to draw a distinction between D-Wing and R1. So the layout, R1 is a large building shaped like an X, and each leg or arm of the X is a wing, A, B, C, and D, and it has a central hub, and that's depicted in the trial exhibits. The assault of Mr. Irving began in the leg, the D wing, and as he was brought out, continued in the hub, and the exit from the building is through a vestibule that is pictured on, I believe it's page 15 of our brief, where there was the first of the most serious assaults in the vestibule, but there were assaults throughout. And in particular, I would point you to page 5 of our brief, where we summarize the testimony and statements of inmate Garcia Rios, who saw inside the portion that everyone agrees is day wing, and saw the assault of Mr. Irving. He said they're beating up an old man, totally unnecessary, picking him up and dropping him. He was saying this in real time to his loved one on the phone. He has no motive to lie about any of it. So in light of that evidence, for the government to get up in rebuttal and assert there was no assault on D wing was contrary to the evidence.
Is the confusion, the speaking past each other there, a matter of location, not a matter of whether a beating took place?
It is a matter of location. The government is arguing that when the prosecutor said on D wing, he meant literally just in that portion that's D wing. The defense is asserting that the whole assault as coming out of D wing was the assault that the prosecutor was denying.
Why is the argument about D-Wing not waived?
Why is it not waived? I think because it was raised in the motion for new trial that the government in rebuttal was unfairly disparaging defense counsel, in part because he was asserting that assault on D-Wing never happened, when in fact that statement by defense counsel was supported by the evidence.
Would you like to reserve the remainder of your time?
Thank you.
Very good. Thank you, Mr. Newhall. We'll now hear Mr. Glazer from you on behalf of the government.
May it please the court, William Glasser for the United States. I'd like to start with the Fowler issue. And as I think the court has already focused on, the government's burden here is not high. On sufficiency review, we have to show only that a reasonable juror could conclude that at the time that the defendant made his statements in his report and to the Illinois State Police, that there was a reasonable likelihood that those statements would reach a federal officer. Now,
our court has only, it looks like, only published Snyder.
Correct.
Snyder, different facts. It sounds like the district court in Snyder was relying on the fact that the state and local authorities, or the state and federal authorities, shared office space. That's a pretty low quantum compared to FBI agents' testimony, FBI attempting to speak to the victim. But we're still in this difficult position of having to determine whether there was a sufficiency. It's a quantum.
Correct.
question.
Correct, Your Honor. I think another distinction between this case and Snyder is that in Snyder, the federal offense only happened The federal offense happened after the obstructive conduct. So the obstructive conduct there was killing the potential witness to what this court considered to be an otherwise local crime. And it was at that point, after the killing, that the federal crimes, arguably there was a Hobbs Act robbery previously, but it was only after the killing that the federal government became involved, and ultimately there were charges brought for, I believe, Hobbs Act and 924C or J. So there, I think the crime was different in nature after the killing, and I think that was important. Whereas here, the crime stayed the same, so there was no change in the crime. It was a crime over which there might be concurrent jurisdiction at the time of the misstatements to the Illinois State Police. So I think that's another distinction. But focusing here on the evidence that we have, and admittedly, we could have called a witness to sort of check the box a little more clearly and say, this is the kind of crime that always gets prosecuted by the federal government or frequently gets prosecuted by the federal government. But I think we came close. And so the evidence that we have is, first of all...
Forgive me, in what way do you think you came close? Because, the government could have easily put in evidence about other times that federal officers investigated prison or guard misconduct at the prison. It is worrisome that the government did not specifically, it would seem, demonstrate that he had to have been aware that his false reports would get to federal law enforcement officers.
Well, Your Honor, just to correct one thing, I think the defense and the government agree that he didn't actually have to be aware of it, have knowledge or intent because of that other provision in Section 1512. He had to have intent to prevent the communication to a law enforcement officer, but with respect to the fact that it was a federal officer, there only needed to be a reasonable likelihood. So we agree with the defense. That's an objective question. And on that objective question, it's true that we didn't, in so many words, have an FBI agent say that there was a reasonable likelihood at the time, or this is the kind of thing that we would always investigate. But we have, I think, 6 different pieces of evidence that were sufficient for the jury to reach that conclusion. If I may, I'd like to list those. So the first is that this was an incident report that was on an official Department of Corrections form that was reviewed and preserved. So these are the kinds of forms that are preserved for subsequent investigation of whatever nature. And I think there was at least a reasonable likelihood that they could lead to a federal investigation. Second, the DOC standards required compliance with, quote, state and federal laws. And each officer, including Lieutenant Scheffler, took an oath to support the Constitution of the United States and to comply with federal law. Third, the FBI agent explained on the stand that deprivation of rights under color of law is a federal offense. Fourth, another FBI agent testified, we work with state and locals a lot, particularly on areas where there's an overlay between both systems. Fifth, there's the timing component here. The Illinois State Police contacted the FBI in early June 2018, before Mr. Irvin had even passed away. So very quickly, the Illinois State Police recognized that this was something that might implicate federal concerns. And then sixth, I think this is important, although we have to be careful about it, ultimately these things did reach the FBI. They did reach federal investigators. Now, I agree with the defense that we can't simply say because this ultimately became a federal prosecution, there was therefore in every case a reasonable likelihood at the time that they would reach federal officers. But I do think the fact that they reach federal officers is an important consideration, because that happened in sort of the natural course of events. There wasn't something surprising or remote, outlandish, or simply hypothetical, to use Fowler's language, that happened to turn this into a federal investigation. It was something that happened in the natural progression of things, and I think this court can consider that fact, the fact that these did ultimately reach federal officers in the usual course of things, to conclude that at the time the statements were made, there was at least a reasonable possibility that they would in fact reach federal officers.
Can we also consider the the gravity of the case or the extent of harm. So, in other words, if the incident involved a slight injury to the inmate versus something of the magnitude here, is that something that we're allowed to consider in trying to figure out whether or not it was reasonably likely that federal enforcement officers would be involved?
Your Honor, yes, I think that is something this court can consider. I would note that there was not specific testimony by a government witness, by an FBI agent about, the federal government investigates more serious crimes versus less serious crimes. So I wouldn't want to lean too heavily into that in terms of the evidence that we elicited in this case. But I think that everything we've been talking about sort of is reflective of that common sense understanding that this was the kind of case that federal investigators often get involved in, and in fact did get involved in here.
What about the sequence? I'm sorry. Go ahead, Judge Rovner.
Is there anything at all in this record about whether Mr. Scheffler had seen other federal law enforcement investigations in the prison of either inmate or guard malfeasance in the 18 years that he had worked there?
Your Honor, none that I can recall from the record, but I don't think that matters because of the thing I mentioned earlier, the fact that the government doesn't have to prove a specific mental state with respect to the federal officer. It only needs to show a reasonable likelihood, which is an objective standard.
So as taking Mr. Newhall's point about the juror's perspective, they might be considering the gravity of the offense, are they also allowed to consider the sequence of the events in that Scheffler files the report of the day of the incident, Scheffler gets investigated the day after the incident, then we get into these calls that he's giving to Banta and various inferences that can happen as a result of how he reacted. Is that all something that the jurors could consider on that third element or not?
Yes, Your Honor, I think it is. I think I wouldn't want to assign too much probative weight to it, but I do think the fact that he continued to interact with his co-conspirators in a way that was indicative of a cover-up suggests certainly strong evidence of his intent to obstruct an investigation. And I don't think there's any dispute that he intended to obstruct an investigation. As to whether, I'm not sure that it moves the ball very far in terms of whether that investigation was reasonably likely to be federal, but on sufficiency review, we think that the evidence in the record here is enough for this court to conclude that there was a reasonable likelihood at the time the statements were made that they would ultimately reach federal officers. Again, they did reach federal officers, not because of an unusual circumstance, something that would be remote, outlandish, or hypothetical, but in an ordinary and expected way. If I may turn now, unless the court has any questions on the count 4,
No,
which I don't believe.
I was going to turn you, but I'm not sure. You want to be turned in in the direction I want to. But Mr. Scheffler argues that the government admitted that its plan was to argue to the jury that Mr. Scheffler's silence was not just evidence that he breached his proffer agreement, but was evidence of his guilt. What is your response to that?
Your Honor, the prosecutor certainly made that statement in a sidebar when the defense was pressing. The prosecutor said it's certainly evidence of consciousness of guilt, and the defense attorney asked, "Are you going to argue that?" And the prosecutor said yes, but ultimately the prosecutor did not argue that. The prosecutor never made, certainly not in the initial part of the closing, and not even in rebuttal, did not make a consciousness of guilt argument. Instead, the only comments on any kind of silence, to the extent we can call it silence, was an argument that Mr. Scheffler had opportunities to correct the record. And that was directly responsive to the defense argument that the government was never satisfied, that Mr. Scheffler repeatedly gave the same story to the government, and that the government wanted him to keep correcting the record, and asked how many times does he have to do it? Every month, every day, every hour? And it was only in response to that the government mentioned that he had the opportunity both before and after the indictment to go back and correct the record. So I agree, the prosecutor indicated that he was going to make a broader argument, but he never did. So I don't think that we have a problem with that statement. If I can turn to the arguments that counsel addressed here, I think first the disparaging of defense counsel, whether this court thinks that it was advisable or not is not the question. The question is whether those statements on rebuttal rose to the level of a due process violation and rendered this trial fundamentally unfair. And although there were certainly, it might have been better if the prosecutor had not begun immediately talking about the defense opening statements and the sustained objections there. This was a fairly tense trial. The defense had gotten up in closing and said, how did they get it so wrong? Accused the government of selecting the wrong person, should have prosecuted the majors and the warden of the institution. And for one reason or another, the prosecutor decided to focus on the fact that the defense arguments weren't evidence. I think that was appropriate, certainly, to say defense arguments aren't evidence, and then reminded the jury of those sustained objections in the opening statement. I think there's just no possibility that the jury convicted here in light of the overwhelming evidence based on those statements by the prosecutor as opposed to the evidence itself. So that was not prosecutorial misconduct, certainly not the kind that would affect the trial's outcome.
Second trial is
Now,
15.
attorney-
I'm sorry. Go ahead, Judge.
Go ahead, please.
Second trial is 15 days long, correct?
Yes.
Do we know how long the first trial was?
Your Honor, I know, and I forgot. I knew at one point, and I've forgotten. I'm sorry.
Shorter or longer?
I believe it was around the same length. Perhaps no. I believe it was a little bit longer. There were two defendants in that case, so Banta was still in the trial at that point.
And do we know it was the same lead counsel in both trials?
It was.
And same defense counsel?
It was.
Okay, thank you.
Yes.
Judge
Same
Rosen.
defense counsel for Scheffler. Obviously, Banta's counsel was involved in the prior trial as well.
Correct.
I'm going to go back a bit. You know, we know, we all know that an attorney should never attack opposing counsel personally.
Yes, Your Honor.
And although it is true, of course, that the district court sustained objections, but after, and then, if I recall correctly, the prosecutor stated that there's nothing more unsupported or discrediting of an attorney's statements than when the court instructs a jury to disregard them. Surely that was a very prejudicial statement to have made.
Your Honor, I don't think it's prejudicial. I wouldn't necessarily say it's accurate that that's the most discrediting thing that could ever happen to defense counsel, but it's not prejudicial, and here's the reason. The district court repeatedly instructed the jury not only that counsel's arguments weren't evidence, but also that objections weren't evidence, and it's just not. It's highly unlikely that the jury would decide after this, again, a trial where there was a lot of intense back and forth between the prosecution and the defense. There was, many times the objections were argued in front of the jury, so the jury knew that this was an intense fight between the prosecution and the defense. In that context, I don't think it was likely that the jury would listen to that statement and conclude from it that it ought to convict Mr. Scheffler, not based on the evidence, but solely based on the fact that the district court had sustained 3 objections in the opening statement. If I may address the other claim that Mr. Scheffler's counsel mentioned, the assault on D-Wing, I think as our brief clarified, there was a conflation in the opening brief between the actual D-Wing and the entryway, and I take the defense to now be arguing that sort of there's an assault on R1 is their main argument, that somewhere in that building, whether on D-Wing or in the entryway, there was an assault. And that would be perhaps a good argument if it weren't for the fact that the government clearly distinguished throughout the trial between those 2 locations. And so when the government in rebuttal said there was no assault on D-Wing, that was completely consistent with everyone's understanding, including the jury's understanding of what happened. The government repeatedly admitted that there was an assault. There was some kicking and punching in the R1 entryway. The government argued that wasn't the kicking and punching that led to the fatal injuries, and I think the evidence strongly supported that view. But the defense would have this court find prosecutorial misconduct based on the government's accurate statement, or at the very least a fair inference from the record, that there was no assault on D-Wing itself. The prosecutor told the jury, we all watched the video, there was no assault on D-Wing. That was a reasonable inference to be drawn from the evidence, and in fact was consistent with the testimony of the vast majority of witnesses, including 3 defense witnesses. I believe there were 7 witnesses who testified that they saw no assault on D-Wing. So it was not prosecutorial misconduct or a misstatement of the evidence to argue that reasonable inference to the jury. I'm happy to answer any other questions.
Do you think that that argument was waived?
Yes, Your Honor. It was not preserved because the only objection that the defense made was in the post-trial motion related to a claim that the prosecution had unfairly attacked the defense by making an argument about D-Wing. So it wasn't this argument. It wasn't a misstatement of the evidence kind of argument. It was an unfair attack on the defense. But even if this court were to consider it preserved, it certainly didn't rise to the level of prosecutorial misconduct.
Thank you, Mr. Glazer.
Thank you.
We'll now hear rebuttal argument, Mr. Newhall, from you. We'll give you a full 3 minutes.
Thank you. Very briefly, I do want to address the right to silence argument. The government agrees that the prosecutor specifically said he was going to make this argument, and it's undisputed that in closing he told the jury he had months after indictment to come forward, that there's no, I think, understanding of that phrase that would not be a comment on the right to silence, and telling the jury that he had a duty to come forward when in fact he had a right to remain silent, and an attack on the remaining silent after the indictment.
Wasn't his argument, though, I mean, that was directed towards the obstruction issue, and wasn't the argument that, he obstructed in this way, and by the way, he never kind of tried to, if it was kind of an honest mistake, he never tried to correct any of it?
I'm not sure what...
It's to deal with, I thought it was more to deal with the issue of kind of intent and whether he knowingly misrepresented as opposed to just kind of accidentally misrepresent, and then he had an opportunity to try to correct that.
I don't think so, Judge Lee. I think that the prosecutor was responding to an argument about how many times does he have to come forward. He came forward, you saw his interviews, because the jury heard recorded interviews, they heard testimony of unrecorded interviews, that he talked to state police, he talked to the FBI multiple times. But he came forward multiple times. The argument was, how many times does he have to come forward and make these statements until they're satisfied? And then the prosecutor came forward and said, well, why didn't he come forward after indictment? He had months after indictment to come forward and correct the record. And there's just no understanding of that phrase that's not an attack on his right to silence after being indicted, which is what the prosecutor said he was going to do earlier in the trial.
Do you want to spend a minute on that Juror 31 issue?
Yes.
Or we can rely on the brief.
No, I would like to address Juror 31. So there is a great deal of deference to the trial judge and credibility determinations, but I think our argument doesn't hinge on the trial judge's credibility determinations of Juror 31. I think that we would say objectively, when you have this many signals of trouble, when you have an outside person, in that case it was Mr. Scheffler's spouse, come forward and say she had overheard Juror 31. Juror 31 denies it, and then the government comes forward and says we have information that someone who has been advocating with the media for conviction, who was a juror in the previous trial, is texting Juror 31's wife, and Juror 31 is again denying that. At that point, it was unreasonable not to strike Juror 31, and that does require a new trial. Thank you, Your Honor.
Thank you, Mr. Newhall. Thank you, Mr. Glazer. The case will be taken under advisement. You started our year off well. Thank you. We'll move now to case number 2 of the day. This is 23-2617, United States versus Coleman. And Mr. Roy, we'll begin with you.
All right, thank you, Judge. Good morning. May it please the court, opposing counsel. My name is Michael Roy on behalf of appellant Lamont Coleman. We raised 3 claims for appeal. First, this court should reverse Coleman's conviction for possession of a firearm because of a constructive amendment. Second, we asked this court to remand for a hearing on Coleman's motion for new trial under Rule 33. And then finally, Coleman's sentence should be vacated and the case should be remanded for resentencing.
On the second issue, was there a request for an evidentiary hearing in the district court?
I would need to get back to you on that, Judge, double check on the record. But I can jump ahead to that claim if that's where you'd like to start.
That's fine, thank you.
Okay. I want to make clear that in terms of the Rule 33 motion, we're not saying that Coleman's filings so far have already proved a claim that he should be entitled to a new trial or new Frank's hearing, just that he has done enough to have a hearing on the issue. And we asked this court to adopt the standard used for 2255, 2254 pleadings, as we lay out in the briefs, although this court has not explicitly stated, as far as I could find, the standard for when a hearing should be held on a motion for new trial. It has recognized that there will be instances where a hearing is required. And I think the 10th Circuit's analysis in Velarde makes sense on why the pleading facts that, if taken as true, would entitle the pleader to relief is a workable standard for Rule 33 motions as well as 2255 motions. However, even if this court were to follow the government's request to instead treat this as like a Frank's motion, and whether he made a substantial preliminary showing to get a Frank's hearing, we believe that Coleman also met that burden.
Did you raise the issue below, though? Because my understanding of the record is that when the defense made the argument attacking the warrant, it was based upon the assumption that the statements in the affidavit supporting the warrant would all be true. And that seems to me very different from a Frank's hearing where the defendant's arguing that the assertions in the affidavit are basically false or fraudulent.
Judge, I believe you're referring to the initial Frank's hearing pretrial? Yes, I agree that we're not challenging any of the rulings pretrial on the Frank's hearing. Although it was titled a Frank's hearing pretrial and the motion was stylized as a Frank's motion, I completely agree that the substance of their claim was just that they lacked probable cause based on the affidavit. And assuming the affidavit's true, the court did not err on finding probable cause. The allegation that Coleman and his girlfriend Katrina were moving back and forth between buildings, that's clearly probable cause. It's on the post-trial motion that it does create a substantial preliminary showing of either material misrepresentation or material omission in the original affidavit. And I think if you go back, though, and look at the initial pretrial proceedings on the affidavit, everyone is assuming that when they're referring to recordings from the surveillance van, that it is existing recordings, not real-time surveillance. They're not using recording in the sense that there's a camera and someone's watching it. They're referring to recordings in the normal sense of the word, that it's making a record. There is a document, there's footage, there's something that exists that the government will be able to provide later.
Mr. Roy, when did Coleman's trial counsel first learn that there had been a problem with surveillance video recording?
And I don't have a good answer for that question, Judge Rovner, because he had a new lawyer when he filed the motion for a new trial. His trial counsel withdrew. We knew that his trial counsel knew something about issues with the van because it did come up at trial, but we don't know to what extent his original trial counsel knew that there was defects in the surveillance van.
So I take it then you aren't, well, I better take nothing. In preparation for trial, did Coleman's trial counsel ever request access to the surveillance video? Do you know? We
do not know because it's not on the record, and that is the type of thing that would need to be hashed out at an evidentiary hearing. And it's very possible.
Yeah, I'm sorry.
Oh, go ahead, Judge Rovner.
No, you were going to say it's very possible.
I think it's possible that at an evidentiary hearing, they would subpoena the original trial attorney, may require Coleman to waive privilege to work product, and have fact-finding on whether the first attorney was aware of this. And it's totally possible that the second attorney, when filing the motion for new trial, did not know what the first attorney was aware of, and that would be a reason he could lose after an evidentiary hearing. But we just don't have.
Do you think that the jury thought it somewhat odd that it never saw any of the surveillance video? And did anyone ever explain to the jury why they were not seeing the video?
I do not believe they explained to the jury why they didn't see it. They instead focused on relying on Katrina as their star witness. We're not challenging the sufficiency of the evidence, though, and we're not saying that disclosure of the errors in the van would have made a difference in the trial presentation, only that it would have been beneficial for the Franks proceedings in filing a more substantive Franks motion. It could have been useful as impeachment evidence if they were able to work off of the disclosure, show that Murray misrepresented something in the affidavit. The impeachment evidence wouldn't be impeaching the video surveillance, it would be impeaching Murray's personal credibility. However, our primary claim is that it would have helped with pretrial suppression.
Spend some time on the constructive amendment.
Absolutely, Judge. For the constructive amendment, obviously, we disagree with the government that the claim is waived. I think that this court's other cases involving claims of constructive amendment where there hasn't been objections, this court has routinely found forfeiture instead of waiver. We laid out in our brief, there's cases of Pearson, so in multiple other cases, Pearson, Withers, like them, those all had no objections to the jury instruction, but the court did not find waiver. It moved on to plain error review. And we completely concede the issue is forfeited and that it's plain error. However, we do think that the error is...
If we find forfeiture, you still have to allege a plain error that affected his substantial rights and affected the fairness and integrity of the judicial system.
Absolutely, Judge. And our position is that we do need to make that showing because that's the standard that applies. And we think we can make that showing. In terms of the error being plain, this case is almost substantively identical to Pearson, although in Pearson, the error was not plain. Pearson made a substantive ruling on whether a constructive amendment occurred in that case. Now this court has guidance. District judges have guidance. We know what states a constructive amendment when there's multiple guns at issue.
I will be interested to hear what the government has to say about Pearson, actually. Yeah. Okay.
We do agree with the government that Pearson is still, persuasive authority on the third and fourth prongs of plain error, since that's not something that the substantive holding in Pearson would affect. But there are some differences in this case. The big one being that Coleman had on prong 3 a defense for the Glock specifically. The Glock was the one gun that could have been Katrina's gun instead of Coleman's gun. And so the government had to show that it wasn't Katrina's by having Katrina testify, I didn't know about any guns, this gun wasn't mine. But we do know the jury rejected other parts of Katrina's testimony, because if the jury had credited everything Katrina said, it would have found Coleman responsible for the specific distribution charges on which it acquitted Coleman, because Katrina's testimony was that he directed those distributions. So I think there's a reasonable probability of prejudice in that he had a strong defense on the Glock. He didn't really have a defense on the other two guns. I mean, they found him in the search, but the jury then could fall back on those guns, and the government primed the jury to do so by repeatedly saying there was multiple guns, opening statements, you're going to hear about guns, multiple guns he wasn't supposed to have. It's true that they clarified a couple times that the Glock was the only gun at issue, but that's no different than Pearson.
How did the other guns come in as evidence, just as part of the search and the argument that, drug dealers use guns and so the other guns are relevant? Is that?
Yes, that's exactly right, Judge Lee. The guns were brought in as evidence, and the argument was that drug dealers use guns. It's evidence that he was a drug dealer. They had, I believe there was an expert that also testified about common characteristics of drug dealing, which includes guns to protect the drugs. And we agree it's relevant for that purpose, since we didn't challenge the the expert or anything like that.
On the waiver issue of the constructive amendment, you cite in your brief a case called Bell. Bell found there was waiver. You attempt to distinguish Bell by saying this is a more complex set of circumstances.
Exactly.
What does that mean? How is this more complex than Bell?
Well, I think our distinguishing of Bell is a little bit different. And Bell is the case the government, I think, primarily relies on to find waiver. Bell didn't really have a thorough discussion of what the substantive claim was, so it's not clear reading the opinion in Bell whether the defendant was challenging only the jury instructions or if they were challenging a Pearson-style, Leeknam-style, this case style argument that a constructive amendment was created by jury instructions, evidence, arguments at trial, and that everything came together.
So if the government or defense counsel had asked for a specific limiting instruction from the court, saying that, ladies and gentlemen, jury, with regard to these other guns, that's not relevant to your consideration of the felon in possession count, would that basically address your argument that it was constructively amended?
Yes, and I think, Judge Lee, that goes to prongs 3 and 4 of plain error. And that if he had objected, they got a corrective.
So I guess my question is, what's the difference between substantively, from the jury's perspective, from hearing from the judge that you can only consider the Glock with regard to the counted issue, and then the government later on in closing saying the Glock is only relevant, the only relevant gun with regard to this count is the Glock?
I think there's a big difference to the jury between what they hear from the judge in jury instructions versus what they hear from the government in closing argument. I mean, you would know, Judge Lee, from experience in the district court, it's very common for juries to be instructed. Arguments aren't evidence. You're not supposed to consider arguments as evidence. You're supposed to follow my instructions. What I say are the instructions of the rules. So I do think a lot of juries are sitting there with the jury instructions. They have the list of elements. They're marching through them together as a jury. The element says a firearm. It doesn't say the Glock. And it's true, as the government points out, they did have a copy of the indictment as well. However, that's no different from Pearson, where they had the indictment in that case, too.
Do you want to reserve the remainder of your time?
I will. Thank you, Judge.
Thank you, Mr. Roy. Mr. Whalen, we'll move to you now for argument on behalf of the government.
Thank you, Your Honors. May it please the Court, Nathaniel Whalen here on behalf of the United States. The District Court did not plainly and constructively amend the indictment. It did not abuse its discretion in denying Mr. Coleman's motion for a new trial, and there was no error at sentencing, so that we ask that you affirm his convictions and sentence. Judge Rovner, you're interested in hearing from me, and I don't want to keep you waiting, so let's hop to the constructive amendment argument.
How about the other two? We'll just let them wait, right? No. What facts do distinguish this case from Pearson?
Sure. The biggest fact that distinguishes this case from Pearson is the actual guns themselves and the interstate commerce stipulation. Pearson involved the exact same gun twice. It's a .45 caliber Taurus brand handgun manufactured in Brazil, both of which were stolen. That's what this court identified in Pearson. When you have the exact same gun twice and you tell the jury you have to convict based on a .45 caliber Taurus brand handgun manufactured in Brazil that was stolen, it's going to be hard for the jury to figure out which one they're convicting on. In this case, the defense argues in his opening argument here that there was no defense as to the other two guns. I'd kind of flip it. We didn't prove the convictions to the other two guns because there was no interstate stipulation as to those two guns. What the interstate stipulation in this case said, and it's page 339 of the transcript, is that the parties agree and stipulate the Glock firearm, Exhibit 4, charged in Count 4, was manufactured outside the state of Indiana and therefore traveled in interstate commerce. There is no interstate stipulation or evidence as to either of the other firearms introduced in this case. So if the jury goes through the instructions, as his defense counsel rightfully says, marches through the elements one by one, they get to the interstate element, there's only one gun that potentially applies, and that's the Glock. And that's the one we referenced over and over in closing statements. We didn't tell the jury to ignore the interstate element. We don't tell the jury to ignore elements of the offenses. What we said on page 410 is the defendant's possession of the firearm was in or affecting commerce. That fact has been stipulated to. There's only one stipulation as to interstate commerce, and that's to the Glock. It could not be clearer that we're talking only about the Glock for the interstate element. Then we continue to say in closing, as Judge Lee noted, remind you, Exhibit 15A, that's the firearm in question. 15A is a picture of the Glock on the bed. We continue, it's the Glock found at the apartment building. We continue, the Glock was found in between the mattress on the bed. We ask the rhetorical question, how do we know that KD knowingly possessed the Glock? Page 411, it was found under the mattress of the bed that he and Katrina slept on. We referred to the Glock over and over and over again in this case, and the Glock was the only one that had traveled in interstate commerce. Pearson establishes a rule that if you introduce, Pearson reiterates the rule from Leichman, that if you give a general instruction relating to any firearm, but you've only charged one firearm, and then you introduce evidence of multiple firearms, that's an error. That's what this court said in Leichman on de novo standard of review in Leichman, by the way. It's what the court reiterated in Pearson. And then the court engages in the plain error analysis of Pearson and asks, is it plain on the facts of this case that the jury would have acquitted on an uncharged firearm? And that's where the court kind of looks at the specific factors in Pearson about what did the government argue? What did the instructions say? Would the jury have been confused about which gun we're talking about when we have two 45 caliber, I want to get this right, two 45 caliber Taurus brand handguns manufactured in Brazil? Here we don't have those concerns. We have, I think, more specific references to the actual gun charged in this case during closing arguments than in Pearson. We have this indictment going back to the jury. We have the court telling the jury on page 24 and 386 that the charges against the defendant are in the indictment. And they're going to look at the indictment, and the indictment itself says, I want to make sure I get this language exactly right. The indictment references the Glock with the specific serial number. There's only one Glock being introduced. There's only one serial number that's discussed at trial. Another difference in this case between Pearson is we actually have an instruction from Judge DiGiulio on page 390. The defendant is on trial here for the charges specified in the indictment, not for any other crimes. That was not at issue in Pearson. And this court actually, Pearson references United States v. Lopez. It quotes it about how that instruction saying not only are you looking only at the charges in the indictment, but you're looking only at the charges in the indictment and no other crimes. That's a different instruction than was the case in Pearson. So Pearson might be good law, and it might be a plain obvious error if you're dealing with two 45 caliber guns manufactured in Brazil, both of which were stolen, both of which were similar appearance, where the prosecutor referenced the gun 6 times in closing arguments, twice specifically pointing to the gun. It's probably plain error as to that particular case. But as the court noted in Pearson, whether a constructive amendment occurred is a fact-intensive question, and the facts of Pearson's case do not lend themselves to clear application of this circuit's precedent. The facts in Mr. Coleman's case still don't allow themselves to a clear application of this circuit's precedent because the circuit's precedent still isn't clear as to what combination of factors renders any error plain. Even if the court has any concerns about the second prong, it's the defendant's burden to meet on the third prong to show that there was no prejudice. Here, the defendant's sleeping on the gun. This is the only gun where we proved all the elements of the offense. Could a jury have disbelieved Katrina that the gun was hers? It could have. Does that meet the defendant's burden on plain error to show he wasn't prejudiced? It does not. Your Honors, unless the court has any questions on that, we'll move to the new trial, or I guess I will move to the new trial argument. Judge Brennan, to answer your question, on docket entry 389, the defendant asks for a new trial. I guess to his credit, he says all other relief just inappropriate. At no point does he ever ask for a specific hearing. I don't know why this court would adopt a lower standard for a post-trial Franks hearing than a pre-trial Franks hearing. The defendant's position is if they allege some facts that maybe show they're entitled to a hearing, that's enough. They don't have to allege a substantial preliminary showing. I guess I don't understand why that would possibly apply when we're dealing with the exact same constitutional issue. Even if you do take his argument and say that you can use the 2255 standard for pleadings to get a hearing, Well, the standard in 2255 pleadings is the allegations as alleged entitle a defendant to relief unless the record conclusively shows to the contrary. Here, Judge DiGiulio heard from TFO Murray 3 different times under oath, at the initial Franks hearing, at trial, and at the sentencing hearing. And Judge DiGiulio found, as a matter of fact, that there was a recording. There had been an issue with transferring it to a physical device, but there had been a recording. And what TFO Murray found, and Judge DiGiulio credited, was that there's this real-time recording, goes up to a cloud-based system, and then there was a malfunction when you transfer it from the cloud-based system to a physical device. So Judge DiGiulio found on Appendix 43, Note 4, specifically, that there was a recording. Defendant has not shown that finding was clearly erroneous. And with that,
When did the government first learn that the videotapes were unusable? And when was that information conveyed to the defense counsel?
Your Honor, that information isn't in the record as to when we first learned that they weren't usable. And, Mr. Coleman's right. The information as to when he first learned about the malfunction is also not in the record. He correctly notes, though, that defense counsel at trial did ask about a malfunction in the recording equipment. It's our position that at that point he knew that it was unusable, or at least that's what the record shows. Ultimately, when he knew the recording was unusable isn't the relevant question. The relevant question is, when did Officer Murray know that the recording was unusable? And there's no evidence in the record anywhere suggesting that happened before he submitted this affidavit.
TFO.
In
TFO Murray, I'm sorry, yes.
Thank you.
in stating that the jury must have known that there was no surveillance video, your brief notes that, and I'm quoting, Detective Slatton had already testified that there was something wrong with the recordings. When I looked at that testimony, it looked like the government had asked him, and there was something wrong with it, right? Something broke down, the batteries? And Detective Slatton answered at some point, yes. I believe so, maybe. Do you think that was enough to let the jury know that the whole of the video was unusable?
I think that, given with the fact that the videos weren't introduced, is enough to know that these videos don't exist in a usable form. But I also don't think it matters whether the jury knew that these videos existed in a usable form. The defense isn't getting up here and arguing that there's a trial issue that was potentially affected the outcome of the trial, or Judge DiGiulio abused his discretion by withholding, by not fleshing this issue out at trial. The defense's only argument has ever been they could have impeached TFO Murray with the absence of a video. Judge DiGiulio didn't abuse his discretion in rejecting that argument. He sat through the trial. He said, you didn't introduce the videos. The jury would have known the videos at least weren't being introduced, if nothing else. They would have known there was an issue with the videos by TFO Slatton. And whether or not you can say, there was a recording issue, that's not going to impeach him, especially when Judge DiGiulio found, as a matter of fact, that there was a recording. At the very least, he didn't abuse his discretion in denying the motion for new trial based on that. And, Your Honors, just one other point on the Franks argument. Even if there were no videos, what this court should do is excise the reference to the videos in the actual affidavit and ask whether there's probable cause. In paragraph 12, the investigators, or TFO Murray, swears that investigators had observed Katrina Owens and Lamont Coleman conduct the same activity prior to several of the controlled purchases detailed above in this affidavit. There's an entire section in the affidavit called Controlled Purchases where he lists out 14 different controlled purchases prior to this recording. So that's what he's referring to, at least in a non-technical, common sense manner. I understand Mr. Coleman says that there are other buys referenced in paragraph 12, and he's right, but none of them are controlled purchases. And TFO Murray says we observed that prior to several of the controlled purchases detailed in the affidavit.
Well, I must tell you that telling the jury that the batteries broke down at some point, to me, is a far cry from telling a jury that the video recordings were unusable in total. I don't think that this, the statement amounts to any kind of material misstatement. But I do wish the government could have been more upfront about the lack of the video recording under all of these circumstances.
Well, Your Honor, I don't think it would make sense. I respectfully disagree, and I think Judge DiGiulio sat through the trial, basically found it was conveyed to the jury that there was no usable video. He sat there through the whole case, and that was his takeaway. I don't think that the government was under an obligation to tell the jury, not defense counsel, the jury, that some videos we're not going to introduce that don't support the counts charged, these controlled buys, there was a malfunction with them. And defense has never argued that they wanted to play the absence of the videos or anything like that to the jury. They're saying we could have impeached TFO Murray. They don't ask TFO Murray about the videos themselves. And they've never said any line of questioning they could have impeached TFO Murray with. And that's what Judge DiGiulio says in his post-trial order.
I would really like to get to Leroy's affidavit because I want to make absolutely certain that we're not conflating two things. Whether an affidavit is reliable and whether it is admissible. I agree that the district court likely should not have placed much, if any, reliance on the affidavit for the truth of the matter. But was it inadmissible?
It was not inadmissible for sentencing purposes, and to the extent that Judge DiGiulio said that, as we noted in our brief, that would have been an error. Had he stopped there, that would have been problematic, but he doesn't stop there. And it's important to read his actual comments within the context of his entire sentencing order and the transcript itself, and not just isolate this footnote. Because if the court reads, as I know the court will, starting with page 16 of Defendant's Appendix all the way through page 22, Judge DiGiulio is dealing with the content of the affidavit. He says, Leroy claimed in a recorded jail call conversation that he and Mrs. Owens were the leaders of the operation. And then Judge DiGiulio finds this assertion contradicts Miss Owens' trial testimony and the observations of the investigators during the surveillance. On page 22 of the appendix, he says the notion that Leroy was responsible for the drug trafficking runs contrary to Leroy's prior statements to the investigators, as well as the overwhelming evidence at trial. So the content of the actual affidavit itself is during a phone call, Leroy stated, me and Trina ran the operation. Lamont Coleman was either at work or at school. Judge DiGiulio dealt with that argument. He said he disagrees as a factual matter, having sat through the whole trial, that that's consistent with the evidence. And so he made a credibility determination between the affidavit and the recording and what he actually heard at trial. That credibility determination is entitled to exceptional deference on review, and it was not clearly erroneous.
Well, it's one thing for a judge to say it's unreliable and that he has not relied on it in making any determinations about sentencing. But it's another, the way I view things, to say that it is inadmissible.
May I respond?
The judge is always free to discredit the substance of the claims in an affidavit, but I think that's a very different issue than determining admissibility.
May I quickly respond? Your Honor, I agree with that, and that's why we acknowledge that it would be erroneous to say that it's inadmissible and just stop there. If the court continues reading the footnote, the court then talks, Judge DiGiulio says, there's no testimony offered about the foundation so as to indicate any indicia about its reliability. So he brings it back to reliability and not inadmissibility. Then in his next sentence, he admittedly goes back and talks about admissibility again. But he says, it would change nothing if it were admissible, because what it states is inconsistent with the trial evidence about the roles of each member of the conspiracy. And the entire sentencing order goes through all the evidence that supports that Lamont and not Leroy is the head of this conspiracy. For those reasons, we ask that you affirm Mr. Coleman's conviction and sentence, unless there are no further questions.
Thank you, Mr. Whalen.
Thank you, Your Honor.
Mr. Roy, we'll go back to you. We'll give you the full 3 minutes for rebuttal.
All right, thank you. I'd like to start first with the government saying that it should be the Frank standard that applies to whether a hearing was held instead of a separate Rule 33 standard. We think that even if it is the substantial preliminary showing required for a normal Franks hearing, Coleman has met that. The case United States versus Clark, cited in the government's brief, that lays out what's required for a substantial preliminary showing. The main point we want to make is it's a burden of production. The court's not weighing the evidence against other evidence. It's not weighing it against the government's explanations. It's looking, and this is a quote from Clark, whether the evidence, quote, permits but does not require an inference, unquote, of a Franks violation. There's enough here for that. There's enough here to infer the possibility that there was material misstatements or omissions in the affidavit. That's all that's required for a hearing under Franks.
What about the government's argument that suppose you are right and then we basically excise the references to the video, and according to the government at least, there's still enough there to support the warrant?
We disagree that there's enough without the videos to support the warrant. As the district court explained when finding probable cause, the sum and substance of the probable cause was from the purported recordings. The other evidence tying Coleman specifically, or his apartment, to the drug activity was fairly weak. There was a lot of evidence that there was drug activity in the apartment building, but they needed probable cause to search Coleman's specific apartment, not just to search the apartment building. And that could be either evidence tying it to that unit or evidence tying it to Coleman as the resident of that unit. But most of the evidence besides the recordings was pretty weak. It was that there was a confidential informant who said KD was the person, but there's no information about how this confidential informant knows KD, why they should be considered reliable, whether they're a rival dealer or someone who has a grudge against him. There was some allegation about the phones being in contact, but Coleman's the landlord. He has friends and relatives who live in the building. Of course, he's in contact. They do allege he's in contact with the drug phone, but it's not clear if they're referring to phone calls or just cell site location, that they're in the same place, which again would be expected in an apartment building. The main thing tying it to Coleman specifically and to his apartment specifically is the recordings. I do want to really quickly talk about the affidavit at sentencing as well. We agree with Judge Rovner that the issue is about admissibility, not whether the judge could weigh the evidence one way or the other. We read the court's alternative ruling different from the government. We don't think the court was saying if admissible, it's outweighed by other evidence. The court said even if it's admissible, it's not helpful because it contradicts the trial testimony. That reads like the court is thinking that anything that contradicts the jury trial evidence is not something that can be considered at sentencing. Would have made sense if he was convicted on all charges, but he was not. Courts can consider contradicting evidence at sentencing. Thank you, unless the court has any further questions.
Thank you, Mr. Roy. Thank you, Mr. Whalen. The case will be taken under advisement. Judge Rovner, should we take a break?
Yes, that would be great.
Very good. The court is going to sit in recess just for about 5 minutes or so. morning again. We'll continue now with case number 3. This is 23-2662, Keontae Mack versus City of Chicago. Mr. Fox, we'll start with you.
Thank you. Good morning, Your Honors. If it pleases the court, my name is Ed Fox. I represent the plaintiff appellant. The district court granted defendant's summary judgment motion and found there was arguable probable cause to arrest and thus qualified immunity because it decided that there was a tentative identification of the plaintiff at a show-up. We're appealing this case in large part because there was not an undisputed tentative identification at the show-up. And that's that was the finding that swung her to the district court to believe there was arguable probable cause. Sergeant Hoover conducted and documented the show-up that occurred in this case. And in his report, he documented what the witness stated at the show-up. The witness name was Marina Clausell. She viewed the show-up, and according to Sergeant Hoover, she readily identified the shooter. And with regard to the second person at the show-up, who was my client, Keontae Mack, she only said, quote, he might be the person who was with, close quote, the shooter. And that's all she said. Sergeant Hoover, who conducted the show-up, he himself determined from this that she was unsure one way or the other of whether or not this person, who turned out to be Mack, was the person that was with the shooter. So he was asked at his deposition why he didn't ask for any clarification of the statement that he might be the shooter. And this was his testimony. It's a quote from his deposition. She had already stated that he was not the person that shot the victim, and she said that he might be the person that was with him, which I interpreted to mean that she was already unsure. So I didn't question her further. I didn't want to push her one way or the other. Consistent with this, and based upon this alone, Brianna Clausell cannot be deemed a reliable witness of a show-up in identifying Mr. Mack because she was unsure. But consistent with this, at his deposition, also, Sergeant Hoover was asked why he sent Keontae Mack to the police station if the witness could not identify him. Sergeant Hoover didn't disagree with the premise of the question at his deposition that she was unable to identify Mack, but rather he only testified that the reason why he sent her to the police station was, quote, I felt that the detectives needed to continue their investigation and decide whether he was involved or should be released without charging. And that was all he had. And case law has decided that when there's a Terry stop made and officers doing somewhat of an investigation during the Terry stop, and the Terry stop does not yield probable cause, even if their suspicions still remain, they have to release the suspect because they don't have probable cause. And that's probably what happened here. There was no probable cause because there was no identification. And
Mr. Fox, can you give us an example of something that you think would actually constitute a tentative identification?
Sure. In the case laws we've cited talk about this. So if somebody says that looks like the suspect, that's a tentative identification. That resembles the suspect, that's a tentative identification. This person is dressed similarly to what the suspect was dressed like, that's a tentative identification. None of that happened here to indicate in any way meaningfully that she thinks that this is the suspect or that this looks like the suspect.
Mr. Fox, let's move to the QI portion of Hoover. We have case law that talks about probable cause and then arguable probable cause, distinction made between the two for purposes of qualified immunity. Offering the arguable probable cause may be a lesser standard than probable cause. How does that factor into the qualified immunity analysis, specifically with regard to Hoover?
Okay, well, the district court found there was arguable probable cause because there was a tentative identification. But there was no tentative, and she found it was a reasonable mistake as a result. And the only other evidence against Keontae Mack was he was located in the area. That was one piece of evidence. And the second piece of evidence was when he was detained, he was completely cooperative with the detaining officers, answered their questions, and showed him his ID. And then the third piece of evidence was the show-up.
And Judge Jenkins is talking about clearly established law with regard to arguable probable cause. It determines that's a basis such that Hoover could not be held liable. What's your response to that? So
with respect to clearly established law, you're not going to find a case on all fours that says if you don't have an identification at a show-up, you don't have probable cause, and he should have known that, because this situation doesn't arise. But there are many cases that say if you have a single reliable, credible witness, that's enough for probable cause. We didn't have a single reliable witness, and those cases have been around for decades. We didn't have a single reliable witness that said that was the person.
Mr. Fox, didn't the officer also have the input of the University of Chicago police officers that said that they had heard, the call go out over their radio, and that they detained two people, that they detained Tucker, but they also detained a second subject that they thought was announced over the radio. Wouldn't that also be additional information that Sergeant Hoover had when making his determination?
Sure, and the fact is, two officers picked these two people up. They picked them up in different, not together, they picked them up and they brought them to the scene. That again is only saying that Keontae Mack was in the area. It's not giving any additional information other than what he already knew. And Sergeant Hoover testified in his deposition that he didn't get any other information other than what Your Honor has just indicated about that. And the reason why I say that, it was some disputed evidence that the University of Chicago officers said they spotted my client and Tucker together, and then Tucker ran. But that was never, A, my client disagreed with that. He said he never was walking with Tucker. And B, the testimony from Sergeant Hoover is they never told him that. So that wasn't part of the equation at all. And even if that was part of it.
Isn't there a third? Because the the University of Chicago Police Department report stated, quote, Breonna could not positively identify Mac Keontae,
Right.
suspect number one, as a suspect.
And
Yeah.
I'm sorry. And that was the point I was going to come to, because not only did their tentative identification didn't occur, but all of the officers that were either present at or near the scene and or who talked to Hoover about it near the time of the incident, they both sets of officers wrote only that Breonna Clausell could not positively identify. They didn't write anything about a tentative identification whatsoever. And in fact, if I can continue on with that, one of the reasons why the inference that should be made, to the extent an inference needs to be made, that there was no identification, is because the first police report that indicated there was a tentative identification was a falsified police report. So this police report was written 3 hours after Barnes, who's the attesting officer on this falsified police report. This was written 3 hours later after he wrote his initial report, where he does not describe a tentative identification. In the subsequent report at 9:30, he describes a tentative identification, and then under penalty of perjury, as it says on his police report.
And you're talking about the supplemental report. Is
Correct.
that the second report? Okay.
Yeah.
Correct. And then, this is his arrest report, actually. And when he was asked at his deposition about the arrest report and about his attestation on the arrest report, he says, that's not my signature, I never saw the report, I didn't write the report. So the first report talking about a tentative ID is a falsified report. And from that, there should be negative inferences taken about the quality of the identification, because why would they have to falsify a report, and why wouldn't the real author of the report come forward if there was not something to hide? So that's the evidence that went into with the reports. The only other reports that describe a tentative identification were made by detectives who weren't at the scene of the show-up at all, and they were the ones that participated in showing the single photograph of Breonna Clausell of the suspect. So the other thing that I think...
So I'm sorry, I guess I'm a little confused. So the supplemental report, right, that's dated August 25th and at 7 a.m., 0700 hours. You're saying that Sergeant Hoover disavowed any of the statements in that report?
No, that's Sergeant Hoover's report you're referring to. He did not disavow the statements in the report. That's the report, I believe, if I'm referring to the right report, where he just says Breonna Clausell stated that that might be the person that was with the shooter.
Right. Isn't that a tentative ID, that he might be the person who was with the shooter?
Well, it's not, because it's not at all. Because as I read from his deposition, where we asked that question about that statement, and he said, and I'll read it again because it is so important. He was asked about that statement and why he didn't ask further questions to clarify it. And here's what he stated, quote, She had already stated that he was not the person that shot the victim. And she said that he might be the person that was with him, which I interpreted to mean that she was already unsure, so I didn't question her further. I didn't want to push her one way or the other. So that was his own interpretation of the report, was that she was unsure. And that's consistent with what he said, a little bit later in his deposition about, not disagreeing with the question that there was a failure to identify, and the reason why he sent him to the police station was just for further investigation, and that he might not be charged at that point. So he didn't believe there to be a tentative identification. And in fact, in his report, he doesn't say there was a tentative identification. So that's if you want to look at, saying that somebody might be the person is not any different than saying that might not be the person. And there was no description of this person that was given by Breonna Classell whatsoever, so they had nothing like that. And so when you have that, and then when you have these issues, and then the falsified police report, and then the fact nobody described it as a tentative identification at the time. The University of Chicago police didn't describe it as a tentative identification. They just said could not positively identify, and neither did the other Chicago police officers who were present. So if that answers Your Honor's question, I can move on from there. And so because there was no identification, what happened back at the police station when Breonna Classell got there was that the detectives that questioned her were aware of what happened out in the field, and they knew they would have to get a real identification if they're going to make the charge stick. So what they did was they showed Breonna Classell single photographs of the shooter and my client. And we all know that's a forbidden practice, and you just don't do that. They've admitted to that. They didn't report it in their lengthy arrest report. They didn't report that at all about showing photographs, but they did it. And it's not disputed, and it's not disputed as a forbidden practice. The defense to that, as well as what the court said, was they said that we only showed her single photographs after she had already said that she picked them out of the lineup at the show up. And there was this huge credibility problems with that, and we pointed that out to the court, and the court said, well, credibility alone is not enough to defeat summary judgment. But the credibility issues with that were that they said that the two detectives stated that Breonna Classell said that she positively ID'd the suspects at the show up, but she didn't. Just 90 minutes before that, she didn't say that, and we know that because Sergeant Hoover said what she said at there. But also,
Did you want to save the rest of your time for rebuttal?
I'll just
Or you
make
can
one
continue.
more point
Sure.
quickly. Is that they gave 5 different reasons about why they would show a witness a single photograph. All of the reasons were inconsistent with one another, and for that reason alone, the credibility issues were enough to defeat summary judgment, and a triable issue of fact on that issue should have been held. And I'll reserve the rest of my time. Thank you.
Thank you, Mr. Fox. We'll now move Mr. Morrell to you for responsive argument.
Thank you, Your Honor. May it please the court. Mack was detained pending trial because an eyewitness tentatively identified him at the crime scene. He confessed to his involvement. Prosecutors decided to charge him after re-interviewing both Mack and the witness. A judge found probable cause to indict him, and the grand jury found probable cause to indict him. Against this backdrop, Mack asserts that the detention was unlawful, but he does not have a viable Fourth Amendment claim because his detention was supported by probable cause, and the officers did not even cause his post-legal process detention.
What are your thoughts on... I'm sorry, go ahead, Judge
Mr. Morrell, let me stop you, please. You have this list of 3 possible categories of identification. My problem is that I see a 4th. What about the witness simply doesn't know category? According to your brief, a tentative identification occurs where the witness is not 100% sure, but indicates the suspect might have been the perpetrator. So this means that a witness who is 99% sure the suspect committed the crime has made a tentative identification. But so is the person who is 0.001% certain has a person who says, I really don't know. But there is a chance it is him, really made a tentative identification?
Right. So I agree. A witness identification of a suspect can fall upon a continuum of possible identifications. You could have on one end a strong ID, that is the person, a strong negative ID, that's not the person, and one could imagine any number of shades of gray of confidence between those two extremes. But what we have here is a witness saying that that might be the person. The only officer who conducted the show up, who was standing there in his deposition, described it as, I did not believe she was, quote, 100% sure. And then, of course, you have the other information that was talked about that helped provide context for that might be identification. A reasonable person, this is where you have the UCPD brought two suspects to Sergeant Hoover, who they claim were seen together near the scene shortly after the shooting, late at night with no one else around, and then the other suspect was positively ID'd. That is all context within which a reasonable person would be interpreting the witness's statement. I think there's also important to note that, you know, the only impressions we have here of what was said was by the only two people there were the witness herself, who both to the detectives at the station and later at trial has consistently said that I ID'd both suspects. And you have Sergeant Hoover's testimony, who said that she was not 100% sure, but I interpreted it as a tentative ID. In addition, it's Mac's burden to show that the relevant case laws clearly establish that the type of identification in this case is not clearly established to establish arguable probable cause. He cannot do so.
Well, as far as I can see at this point, there is an issue of disputed fact about what Ms. Clausell said and whether this gave the officers probable cause to arrest.
There is only two statements in the record by people about what she said. What Ms. Clausell testified herself, and what Sergeant Hoover said he heard her say. Both of those, so there is no dispute of fact, because those are the only two people who were present at the show-up who said what she said. To the extent the opposing counsel is relying upon the incident report where they used the phrase "could not positively identify," Officer Raisin Barnes, who were not the show-up, were asked during his depositions where they got that information from, since they weren't there. And they said it, quote, came directly from Sergeant Hoover, who told them that Clausell positively ID'd one offender and tentatively ID'd the other. So all the information about the show-up necessarily came from Sergeant Hoover and Clausell, who told them that Mac was tentatively ID'd, and they just described in the report using slightly different language to say the same thing. Indeed, that one sentence...
Your brief also states that the detective showed Clausell a single photo of Mac and Tucker to clarify which suspect was the shooter and who was the accomplice. But that is not what the detective said they used it for, is it?
That is what one of the detectives, I believe, said they used it for. I agree there is some disagreement among the detectives about why they showed that photograph, but that is a completely separate issue from when they showed the photograph. And at the end of the day, you know, there's two different periods of detention here. There's the pre-legal process period about when they initially took him to detention. That's what we're talking about, the tentative ID. And then there's the rest of the vast majority of the period of detention that was determined post Gerstein hearing. For the vast majority of Mac's pre-trial detention, not only did you have the tentative identification, but you were supported by Mac's confession and the further interviewing of the eyewitness who told the detectives that she identified both of them. Mac's confession alone was sufficient, in fact, for probable cause. And nowhere in Mac's briefing does he really explain why his confession does not end the probable cause inquiry.
Are you talking about the confession to the officers or the confession to DeBoney?
Well, both of them. And I think that gets to the causation issue, which I can address as well. Because when you're talking about the post-legal process period, you know, for the vast majority of time of detention, you have issues of both, was there probable cause? But then separately, independently, did the officers even cause this detention? But on the issue of probable cause, what's relevant is that he confessed. And now, while Mac argues that his confession was involuntary and in violation.
But if there wasn't, if she did not identify him, then we don't go any further. That means, and as for the post-legal process detention, Clausel was clearly more confident in her identification of Mack as the non-shooting accomplice. But isn't it possible that she became so much more confident about her identification when she was influenced by being shown a single photo of Mack?
Well, there's two things here. One, on that topic, again, there is absolutely no evidence in the record to put in dispute when she was shown that photograph. Clausel and both detectives, which are the only three people who have testified on this topic, have said that she was not shown the photograph until after she reaffirmed her identification from the show-up. The prosecutor then also showed her a single photograph, but that gets to the causation issue. As to your point about, well, do we go any further, I actually don't think that's accurate, Your Honor. Even if there was not a probable cause for the initial period of detention, the first, let's say, 12 hours, or it wasn't even that long, once he confessed and once additional evidence came in, there was then probable cause moving forward, and there was a judicial determination of probable cause at the Gerstein hearing and the indictment by the grand jury, both of which are presumptively valid. So while there are definitely...
We have to recall Hoover is the only one who actually heard her. And she said that Mack might be the person that was with the shooter, which I interpreted to mean that she was already unsure. That is what his report said at 146-9 at 37. Further, he said she stated he might be the person that was with the subject that shot her. And that's at 38. She wasn't 100% sure. I should say she wasn't. That's at 36. The only statement she made to me was that he was not the shooter, but he might be the person who was with the shooter, and that's at 39. And to me, those paraphrases of her statements seem far more like, I don't know, rather than, I'm not 100% sure, but he may have been. And anyway, I have a problem, as you can see.
I will say that the might be statement in the context of the other information he had known at the time was enough to establish tentative probable cause, which I will say the opposing counsel does not disagree that a tentative ID can establish probable cause, and he admits in his reply brief on page 4 that he found no definition in the case law of what is meant by a tentative ID. Nor does he cite a single case where a trustworthy eyewitness is described as something more than a negative ID on the continuum of possibilities of confidence, but a court nevertheless held that the ID was insufficiently definite to establish probable cause to detain. There's absolutely no cases that he cites in his record, no definition of tentative ID to do that. So when we're talking about in the context of at least arguable probable cause of qualified immunity, that failure means that Mack has not met his burden of showing that there's clearly established law to overcome the officer's qualified immunity. But even if the tentative ID could not justify the initial arrest, which we disagree it was, for the vast majority of the detention that we're talking about, it was supported by his own confession. He doesn't even explain why the confession is not enough to support the vast majority of his pretrial detention. As this court has explained in Hurt v. Wise, reliability, not coercion, is the gravamen of probable cause. The detectives asked Mack open-ended questions, to which he provided details that matched the details the eyewitness separately told the detectives. Even if, hypothetically, Mack only volunteered this information because of their interviewing tactics, which is not the case, there is no evidence in the record to support that a prudent person in the detective's shoes would have reason to doubt the reliability of the inculpatory statements Mack ultimately made. In addition, and this gets to Judge Brennan's point, Mack never claims that his separate interview with the assistant state's attorney was at all coercive. And during that separate interview, Mack again confessed to the crime and provided unprompted, new inculpatory information for the first time, such as the model of the victim's car. Mack has no argument whatsoever for why this additional confession does not sufficiently establish probable cause. But there is a third issue that we have to address here for probable cause, for the pretrial detention, which is causation. Mack's post-legal process detention claim also fails for the lack of causation, as shown by this court's recent decision in Washington v. City of Chicago. In that case, the court explained that the chain of causation for police liability is broken when one of two things exists. Either the prosecutors perform their own independent fact-gathering before filing charges, or if the purportedly problematic evidence is taken out of consideration and the remaining evidence is still sufficient to support the judicial probable cause determination. In other words, the evidence must have actually been decisive and tipped the scales in favor of probable cause. Here we know not only that the prosecutors did their own fact-finding, including conducting interviews of both the eyewitness and Mack, where Mack confessed again and Clausel seemed confident of her identification to the prosecutor, but we separately know with confidence that any purported issue with Mack's confession was not decisive for judicial probable cause, because Mack does not even claim the confession was used at his Gerstein hearing or at any point in
What
his
is
case.
your what? I'm having trouble keeping up with you.
Sorry, yeah.
What is your response to Mack's argument that a confession that initiates a criminal proceeding can be challenged under the Fifth Amendment?
Well, first of all, that would not apply to his Fourth Amendment claim, which I'm sure Your Honor is aware, so it still wouldn't get him out of the causation for Fourth Amendment purposes. But if we're talking about the Fifth Amendment claim, no, it does not constitute a courtroom use under the Supreme Court's decision in Chavez. There, the court specifically talked about the sort of use in, quote, criminal investigatory process preceding the commencement of a criminal case that the Supreme Court said was insufficient in Chavez. Now, when this court took up the mantle after Chavez in Sornberger, they said that, this court said that even preliminary hearings, that then would be enough. So when the court was talking about in Sornberger these preliminary hearings, they're saying that that would be enough of a use in a criminal case when you're talking about the commencement of a criminal action, which is actually when judicial probable cause determination was found. No case that this court has talked about since Sornberger has ever indicated that something outside an actual use in a preliminary hearing would be sufficient to be a use in a criminal case. In fact, in Jackson v. Curry in 2018, this court specifically talked about how Sornberger was extending the Chavez doctrine to preliminary hearings. That's not what you have here. There's no argument it was used at the Gerstein hearing. There's no argument it was used in the grand jury process, and there was no argument that it was used at any point in his criminal case. But even on the merits of the Fifth Amendment claim, the confession was not coercive as a matter of law, because the will of a reasonable person in Mack's position would not have been overborne. Mack waived his Miranda rights multiple times to speak with detectives. The entire interview was about 16 minutes, and he started making inculpatory statements after about 10. He was not held for a long time before questioning began. He was asked open-ended questions that were not leading. He was not deprived of any physical needs, such as food, sleep, or bathroom access, nor was Mack ever offered any false promises of leniency nor threatened. Accurately being informed that he would likely spend a long time in jail if convicted of murder is not a coercive threat that destroys his rational choice whether to speak to detectives. The detective's interrogation was entirely within the bounds.
Do we factor in the fact that he's 17 years old?
Under this court's precedent, the factor is not sufficient to do it, but it can, if there is, for example, improper threats, it kind of colors the way those improper threats may have been interpreted by a 17-year-old. But here, we don't have any improper threats whatsoever, so it doesn't materially change the analysis.
You don't think it's a threat you could be held for murder?
I think accurately informing someone that they're a suspect of murder does not destroy someone's rational decision whether to speak with detectives. If anything, one would imagine that they would make you more hesitant to what you say. For these reasons, the judgment of the district court should be affirmed.
Thank you, Mr. Morrell. We'll now move back to Mr. Fox for rebuttal argument. Mr. Fox will give you 3 minutes.
Thank you, Judge. I just want to correct one thing. There were more than just 2 people that testified about the show-up. Plaintiff was there, too. He testified to it. He heard her say she was unsure, similar to what Sergeant Hoover's testimony was. And I just want to make that point clear, that he was also there to say that. With regard to the confession, and things that were said are just not accurate, and you will have the transcript of the confession. My client was 17 years old. He had been up all night, not sleeping, and he was wearing a paper smock and was cold when he was interrogated. But he denied being involved. He denied being involved 9 times. And each time he denied being involved, Roberts would yell at him and either call him a liar or say, and excuse my language, but this is what he said, you'll go to fucking prison for 50 years unless you give us the truth. my client also asked for a test, a polygraph test. He was told by Roberts at one time that he denied it. Roberts said again, those tests are nonsense, and then proceeded to threaten him some more. So this was not a simple matter of him just confessing. 9 times he denied being involved before he finally said, and then even after that, he was so equivocal. He was so equivocal and didn't know so many of the core facts of this that the prosecution didn't even use the confession at trial. And the statement to DeBoni that came later was so equivocal because that it was useless. And I don't even think you could really call it a confession because he said he didn't know. He said, I don't know, to almost every third question that was asked of him at that interview. So the confession...
He thought there were 3 women in the car.
That was one of the things he said it was wrong. He thought there were 3 women in the car, among other things that you said it was wrong. And then when he said, I don't know, Officer Roberts then offered him the facts of what he should say. Officer Roberts said, well, didn't he say you want to do a lick? And then of course he mimics it and says, yeah, I want to do a lick. But when he had the same interview in front of DeBoni, he said, yeah, he said I want to do a sting. So he couldn't keep the story straight because it wasn't a true story.
Obviously, Mr. Mack won at trial.
Correct.
We've also had this overlay of qualified immunity, though.
Correct.
We've got to analyze the case pursuant to that. We've had a lot of discussion about probable cause. Your final thoughts on qualified immunity?
My final thoughts on it is that qualified immunity does not apply, even if there's no case on point, when the conduct is so outrageous that any officer would be aware of it without a case on force. Any officer would know that if all the evidence you have is a guy's in the area, but he cooperated with the detaining officers, and then when the witness came to do the show up, she said she was unsure, any officer would know you have not enough by a long shot to arrest somebody at that point. So I think it's just, and there isn't going to be a case on point because officers don't, as a general rule, officers aren't going to make an arrest unless there's a reasonable identification, some sort of meaningful identification. Even if it's tentative, if it's something meaningful, like he looks like he's similar, he's wearing the same clothes. That didn't occur here. It's just so obvious. In this case, there just isn't a case on it because it is so obviously wrong. And so those are my thoughts on this, Judge.
Thank you, Mr. Fox. Thank you, Mr. Morrell. The case will be taken under revisement. Our next 2 cases on the calendar have been submitted on the briefs. We're going to move to Appeal 23-2605, United States versus David Odom. Mr. Luthen, we'll begin with you.
Oh.
Good morning, Your Honors, and may it please the Court. Elliot Louthan on behalf of David Odom. This appeal raises 2 issues regarding supervised release. First, whether 4 of the new conditions imposed below have the requisite precision and particularity that this Court requires. And second, whether a fully secured card suffices as opening a new line of credit, a finding that the District Court made for one of the violations below. Now, starting with the first issue of the conditions that were imposed below, I'd like to begin with an observation regarding harmlessness, because harmlessness theoretically applies to all 4 conditions. Besides complying with this Court's directions to raise these issues and contest the objections, or contest the conditions below, there's a practical reality that I think is worth underscoring. And that is when this Court, or when the government suggests that these conditions can be later modified, the typical defendant, when they transition from prison to supervised release, doesn't have a lawyer representing them. And this has been the case in our practice in the Federal Defender's Office. We are usually appointed only once a supervisee has had a petition to revoke filed against them, in which case where then a defense counsel is being reactive. And so the idea, what I'd like to underscore is that the idea that modification is a cure-all is really a siren call, because a defendant is unrepresented, and the idea that they're going to transition from prison to supervised release and know to challenge arguably vague conditions at the outset just isn't how the average supervisee is going to begin their term of supervision. And that's why we think that harmlessness does not apply.
Let me focus in on standard review for a little while. We've got the fiduciary condition, the business ownership condition, what I call the alcohol condition, and then the community service condition. Some of the arguments here are vagueness, and we have to confess our court's law has not been as clear as it could be with regard to standard review. I'd like your thoughts on the first two, the vagueness and the business ownership, the fiduciary and the business ownership. Are you arguing those are vagueness de novo review?
Yes, Judge Brennan.
And then on the third and fourth, the alcohol and the community service, are those a failure to justify and therefore an abuse of discretion review?
The failure,
The alcohol and the community service.
the alcohol one was failure to justify, and so would be abuse of discretion because there was a proffered justification, reasonableness. As to the community service condition, my position is that it's procedurally infirm. There was no explanation given at all, and so that would be reviewed de novo because it's a procedural challenge.
And I'm aware the government's got positions with regard to waiver, et cetera, with regard to those, and we'll hear from them. But I just wanted to get your thoughts on that.
Yeah, absolutely. So yeah, and the order that you just outlined, the conditions really reflects the concern, the priority of concern that Mr. Odom has with these conditions. Now, absolutely, we're not conceding any of these four, but the vague conditions are definitely at the forefront, and that there's no doubt that he understands, and as his lawyer, I can explain to him what the heartland of those conditions entails. No question about it. But it's the limits of those conditions that are concerning, because it's those limits that often are the subject of petitions to revoke. And it's the limit of fiduciary responsibility and the limit of business ownership interest and or affiliation that is quite concerning. And the government in its response brief doesn't even attempt to delineate those limits. So that's why we think that those conditions need greater clarification so that they provide the notice that this court requires.
Shouldn't we, though, also consider the fact that Mr. Odom is or was a lawyer? And so to him at least, I don't think there's much of an argument that he didn't have enough notice, that he himself didn't have enough notice as to understand the extent of fiduciary responsibilities because, as particularly in a lawyer in the area that he practiced, one would hope that he's familiar with what fiduciary responsibility means.
Well, two responses, Judge Lee. First, this court's case law on what the operative doctrinal inquiry is doesn't account for professions. One's profession is just whether a person of reasonable notice. So I don't think we consider his status as a lawyer. But even if we do, two follow-ups to that. One, as it lay out in the brief, I think what the meaning of fiduciary responsibility is highly subjective. And second, it is not a trained lawyer who is enforcing this condition. It's a probation officer. And that's a point that this court in its Thompson and Capps and Siegel made, that the fact that there's open-ended delegation is problematic because a probation officer who's not necessarily trained in the law is the one enforcing it.
So how would you propose that this be worded? Does it have to give an exhaustive list of all the different types of jobs? I mean, at some point, a generalized description is always going to be subject to your argument that it's somehow vague on the fringes.
For sure. I mean, there's grayness in words always. But one, if a condition of supervised release is going to necessarily be so vague that it's an open-ended delegation, then don't impose the condition. To this point, there's a separate condition, but that special condition 4 that I think gets at a lot of what this condition is, what the fiduciary responsibility condition is trying to get at. You shall not maintain employment where you have access to other individuals' personal information, including but not limited to social security numbers and credit card numbers. And that's quite specific and objective. And so to the extent that the sentencing court is concerned with him having power over someone's financial information, I think that condition more objectively gets at that goal.
But look, if circumstances arise where an individual cannot be sure whether his behavior involves fiduciary responsibility or a business association, why can't he simply seek guidance from the probation officer or the district court?
Well, he certainly can. That recourse is always available. But in the meantime, we have a probation holding that condition over the defendant or the supervisee's head, potentially abusing the probation officer's discretion in taking a too broad of a meaning. And then if they file a petition to revoke, as this court laid out in St. Clair, it's too late to challenge the vague condition. And so we're just asking for greater clarification now.
I think that would be so difficult, to do. And here we have an individual who seemed to be undeterred by many restrictions on his conduct, both from the bar licensing authorities and from probation services. Don't you think that some breadth of terms were necessary to keep him from finding ways around the restrictions?
Well, two responses to that, Judge Rovner. One, we're not contesting that a condition pertaining to his employment, limiting his employment in some way, could be appropriate. Second, I'm hesitant to say that the poor character or the questionable judgment of my character somehow, of my client somehow diminishes or hollows the due process and notice right that he has to terms of supervised release that are not vague, terms that are regularly imposed and will apply to other criminal defendants in this circuit who, similarly will have different probation officers interpreting those conditions. And so I don't quibble with Your Honor's point that there were points where he was undeterred, but I don't think that should factor into whether the condition itself is vague.
I'd like to reserve the rest of your time.
I would like to just ask
Sure.
You this. Let's say that we decided that he did not violate a condition of a supervised release by getting 2 secured debit cards. What would this do for him in a practical sense?
In a practical sense, it would allow him to obtain those sort of cards now that he is already on supervised release because that condition was already imposed. And to the extent, and that is the thrust of why it really matters. It's also a condition that is routinely imposed for defendants who are convicted of or have fraud convictions. And so it's bigger than, there's a systemic interest as well. But the practical reality for him is that he has that condition once again, and probation theoretically will limit his ability to obtain a secured card.
Judge Bryan, can I ask?
Absolutely.
So there's some confusion in the briefs, or maybe I'm just confused and the briefs are clear, between a debit card and a secured card, right? And it seems like there may be 2 different types of secured cards. One is where you basically prepay, in other words, like a mobile phone prepaid card, right? And the other one is where you're basically putting down a security deposit.
Right.
That is, you're putting down money and you could maybe spend beyond that, right? But the bank still has that security deposit. And I guess, and so which type of cards are we talking about here?
Your confusion, I think, is emblematic of the government's failure to prove this condition below, because we don't know. And my understanding is that it is more so of the secured credit card where there's a deposit down, and that means that the bank takes on no risk of loss.
And
but
in that
it wasn't ever unpacked below what the specifics of this, and that's why I think the government abandoned this theory in its closing argument, never mentioned the credit report or elicited testimony about the credit report. And that's why you don't see Exhibit 15 come up ever in the transcript.
And your understanding of the second type of card, that is where you put down a deposit, can someone using that card exceed that deposit?
I don't think so. And if that's the case, then I would agree that the lender is taking on risk there, such that it is a kind of card that the condition contemplates. But when it can't go over and you can't exceed that limit, my understanding is that that these cards weren't that case, nor is there any evidence in the record to support that either it could be exceeded.
And did those arguments come up? Did defense make those arguments below?
No, because the government never discussed this. I mean, the government still had the burden by a preponderance of the evidence to establish the violation. The thrust of their argument, of their allegation below, was on the auto loan, because that clearly sufficed. But he had arguably had permission, which is why the district court found that wasn't a violation. And so that was, which is the fact that the government abandons that theory, is why Mr. Odom's defense lawyer in his closing really just briefly skirted past those cards, because it seemed like it had been conceded. The focus was the auto loan.
Okay, thank you.
When you reference Exhibit 15, are you talking about the Equifax report?
I am, Your Honor.
And that's not in the record, is that correct?
I believe it is. I believe the exhibits would be in the record. I don't know the exact record number off the top of my head.
Thank you. We'll give you some rebuttal time.
Thank you.
Thank you.
Judge Ryan.
Ms. Bonamici, we'll go now to you on behalf of the government.
May it please the court, counsel, Deborah Bonamici on behalf of the United States. The district court did not err in imposing the challenge conditions, because those conditions were neither vague nor unsupported.
Ms. Bonamici, I am struggling to understand how a credit card that a person fully secures with cash can be considered a line of credit. In other words, what credit has the bank extended? It seems to me almost no different than a traveler's checks. Or is your argument simply that no one really knows what these credit cards actually were?
No, Your Honor, that's not the government's argument. I think the best way to explain it is to distinguish the three types of cards that Judge Lee referenced. That is a prepaid card, a debit card, and a secured credit card. With respect to a debit card or a prepaid card, the defendant, or the cardholder deposits money that is used to pay the charges as they go along. So the cardholder presents the card, but then the lender or the bank pays with the defendant's money, essentially.
Right.
And that money is drawn down as the charges are paid, right? In the context of a secured credit card, it's different. There's a deposit made by the defendant, and in a fully secured credit card like the ones that are at issue here, the amount of the deposit is the full extent of the credit. But what the defendant is permitted to do, and it's structured this way, the defendant can make regular payments on the card, and so that deposit is not touched, it's not used, and the full amount of the deposit remains credited to the account. The purpose, one of the primary purposes of such secured credit cards is to allow defendants who need to cardholders who need to rehabilitate their credit to prove that they are creditworthy, that they can be trusted to make the regular payments.
Secured versus unsecured.
Correct. So it serves in the secured credit card setting, it serves essentially as collateral, whereas in the other two settings, it serves as the pot from which the payments are made.
But in either case, as Judge Rovner says, the bank doesn't really take a risk, right, of non-payment, because the bank always has, even in the secured credit card context, the bank always has the initial deposit to fall back to.
But the definition of credit isn't based solely on the amount of risk assumed by the lender. The definition of credit is what is being done, what is actually being provided or extended to the borrower. And in this case, what's being provided is an opportunity to borrow the money when the purchase is made, right? And then to pay back that money borrowed on a regular basis. And as long as that's done, the deposit or collateral remains fully credited on the account. So when you borrow, and that's how you know that the money actually is borrowed and that credit is extended, because that deposit is fully credited on the account as goes along. But
then what would be the justification for prohibiting such credit cards, right? And so if we're worried that this person is going to commit fraud, then why prohibit him from getting a secured credit card? Because there's no opportunity in that context for him to commit fraud.
There's no opportunity for him to defraud the bank, perhaps, or the provider of the card, the lender. But that's not the only reason why lines of credit are monitored by probation and why that condition is imposed in many fraud cases, right?
And I'm trying to understand what probation's justification would be for prohibiting anyone from getting a secured credit card.
The concept here is that all of the financial transactions that a person who's committed fraud, and not to mention a serial fraudster like the district court found this defendant to be, with a remarkable history of variety and quantity and continuous.
Right. That's none of that's disputed.
That whenever he is expending money, borrowing money, engaging in financial transactions, that may have an impact on his restitution, his ability to pay restitution. It may have an impact on what he is getting ready to do next in terms of maybe building up his credit so that he can, eventually move into the next dimension. It's just a question of financial security or financial monitoring as much as anything else in that context, and that matters a lot, and it's not a non-issue. The question here, the issue here, and by the way, this is a case where a defendant, not surprisingly, did not inquire as to his ability to do it, did not do any of that, did not inform the probation officer after having done it, and is clearly a situation where the probation officer was unable to monitor his ability or his conduct. So he had every opportunity to ask whether he could. He had every opportunity to fight the probation officer by raising it with the court afterwards, and this court takes that into consideration. So, drawing from this to the more general points, it is. I don't know that there's any evidence to suggest that these issues arise mostly after rules to show cause have been filed.
It's the government's burden, of course, to show by a preponderance of the evidence that he took out a line of credit, right?
Correct. And the document that we provided,
and you're saying that is what he did.
That is what he did, and that the document that we provided, it's true. As the defendant acknowledged in his opening brief, the government didn't put a lot of time on this issue because there were so many other issues, many of which were much more important. That's true. But we did present documentary evidence that established both that the account itself was described as a line of credit and as a revolving line of credit, that it was tracked and monitored the way credit cards and extensions of credit are tracked and monitored for credit score purposes, unlike debit cards and prepaid cards, which generally aren't tracked at all. So this document did establish those facts, and the only evidence that the defendant presented was his own self-serving testimony on the point, which the district court discredited entirely, actually finding that the defendant had perjured himself.
So, bottom line, what kind of credit card can he have?
He can have a credit card that the probation officer approves.
Or a debit or a prepaid.
Right. He can have anything that the probation officer approves, and if he is up to date or he has paid his financial obligations, which would be difficult for the defendant in this case with such a large restitution amount, understood. But generally speaking, the condition does not apply after the defendant has fulfilled his financial obligations under the sentence.
And the reference to the document is to Exhibit 15, is that right? Okay.
Yes, Judge. And it's true we did not put on a witness to further elaborate it.
And
it's very confusing.
And the conditions, the initial conditions, don't require him to provide just his financial information on a routine basis. Is that correct?
they require it at the request of the probation officer, and the probation officer is routinely requested. So
Does that include like bank statements and all that other stuff?
yes, there are those forms that he filled out falsely, I might add. And Judge Lee, you've made an important point, I think, about considering the defendant's background too. You know, supervised release conditions are imposed in the specific context of a particular case. You know, the standard for reviewing this is objective, but that doesn't mean that the court ignores the fact that the defendant in the particular case can understand the conditions as written. That would be ridiculous. As well as the defendant's opportunity to challenge those conditions or to seek clarification from the district court. This court has recognized that those are relevant topics in assessing a vagueness challenge. And the defendant also, I mean, his suggestion basically is that these conditions need to be written so as to delineate every possible, set of facts that might apply, and to determine which side of the condition each potential set of circumstances would fall. And that's not the law, and it's not in any way practical, and it's not warranted in a case, especially in a case like this one, where the evidence demonstrates that the defendant has suffered and is not likely to suffer any prejudice at all from any aspect of these conditions. So for all of those reasons, the vagueness, I see I'm out of my time, the vagueness challenges should be rejected. With respect to, with the court's permission, I would like to just address the other three challenges. With respect to the alleged failure of the court to support either the community service or the alcohol. With respect to both of those conditions, the district court, as to the 100 hours, there's no argument about a failure to support the substantive nature of that condition. And the 100 hours, the defendant did not raise a question about justification. He merely argued another number. The district court clearly compromised between the two numbers. And remembering that the maximum was also limited by the number of hours that could be served per week. It was limited to 8 hours per week. So although there was a maximum and a debate over the maximum, there was no challenge to the 8 hours per week, which fundamentally limited that condition. With respect to the alcohol, the district court could have declined to apply the alcohol condition in these circumstances. Fairly read, we believe that the district court agreed with the prosecutor's statement that, which was based on common knowledge, really, that alcohol is not a good fit with somebody who's suffering from clinical severe depression, and that it's problematic in that setting. If the court were to find that the court's justification was inadequate there, or in the case of the community service, the proper result would not be reversal or remand for resentencing. The proper result would be for the court to vacate those conditions, and with leave for the government, if they thought that it was important, to seek a modification, as both parties are entitled to do under Rule 3582E.
Thank you, Ms. Bonamici.
Thank you, Your Honor.
Mr. Louthan, we'll go back to you for 3 minutes for rebuttal.
Thank you, Judge Brennan. I'll try to be quick. As to the credit issue, Judge Lee, to your point of this is really being about financial monitoring, or that seems to be what the government is suggesting, I think special condition number 6 gets at that, where the defendant has to provide financial documentation whenever requested. And as the first 5 minutes of the oral argument for the government all centered around what the details and the particulars of this condition and whether it was proven, where was that below, right? That is part of our argument. Second point, there's been a lot of conversation around harmlessness, right, and the ability to modify a condition. On page 17 of the blue brief, I flagged multiple cases, Siegel, Bickert, Thompson, cases where this court found conditions were vague. those cases would have no meaning if harmlessness applies simply because a defendant can subsequently seek clarification. And so to the extent that this court is inclined to disagree with our position that fiduciary responsibility is not vague, business interest and affiliation is not vague, I would urge the court not to conclude that it's harmless, because that would apply to every vagueness challenge. Instead, if the court believes that those words are sufficiently defined, then so be it. But harmlessness, I think, sets a slippery slope in terms of precedent. And even still, the government has not set forth any sort of dividing line or offered any limiting principle as to what fiduciary responsibility and the business interest and affiliation conditions mean. And so Odom and future defendants who have these conditions are still will be at a loss and subject to a probation officer's interpretation.
Currently, Mr. Odom, he finished the 16 months of re-imprisonment. He began the 12 months of supervised release again in June. Is that right?
Yes, I believe that early July, between June and July. And
Does he have a release date?
he's out.
Oh, he's out.
Yeah, which leads me to one of my final points.
I should say release from supervised release.
No, he's on supervised release
And
currently.
what does he have a date when that's to end?
12 months after his official release date. I apologize. It'll be next summer.
Okay, thank you.
And so that actually leads me to a final, or second to last point. I know this is the beginning of the term, and Your Honor, it's very busy with new cases, but to the extent that a decision could be reached, the expediency of it very much matters to him because he's already a few months into his supervised release term. Final point regarding the alcohol condition, the district court's reasonableness. I see I'm out of time. If I
You
may.
can finish your last one.
Thank you, Judge Brennan. Reasonableness can be said of every condition. And this alcohol condition, while surely not burdensome for someone like Mr. Odom, is routinely applied. And the government's suggestion that simply because someone has mental health issues that this condition should apply is troubling and should give the court pause, because this condition comes up in almost every single criminal sentencing, and so many of our clients have mental health issues, and that the notion that their liberty can be restricted simply because they have mental health issues, I don't think is sufficiently particularized, nor is it the justification that the district court below adopted.
Thank you, Mr. Laughlin. Thank you, Ms. Bonamici. The case will be taken under advisement. That will complete our hearings for today.